actor in black robes. Federal Rules of Civil Procedure 44.1. It's the only place where it is found it says judge is an actor. The clerk of the courts, however, sits on plane number 1 in most courtrooms. Up until the time I put this presentation up here and blew the secret on clerks, they then took the clerks off of the same plane as the claimant in the basilee. A basilee is a servant employee of the courtroom, which is your prosecuting attorney, and you are the claimant. Don't call yourself a respondent, because re means no speak. Defendant means no contract. So don't get involved with no contract language. The clerk was then moved off of plane number 1 into its own separate plane. When you take the witness stand, you're going to move yourself from the common and you're going to put yourself into a box. And in that box, the witness cannot hear evidence or give evidence and cannot produce any testimony. So it's mute argument. The jury box is on a different plane as well. And the jury box, when you look it up in Black's Law Dictionary, says this is an enclosed area that cannot witness, cannot see witnesses or hear testimony. Yep, read it for yourself. It's all been published. They're in a box, aren't they? Which is an enclosed area. And therefore, there's no continuance of evidence between the jury, the judge, the claimant, the basilee, or the clerk. The whole thing is all mute. Everybody is talking to nobody. The contracts are written in adverb verb. Nothing is being contracted, nothing is being said. And what did I tell you about what is the court? The court is the document. The Constitution are the words on the document. If the Constitution is written in adverb verb, and I swear to support the Constitution of the United States, between two people who said nothing about nothing on nothing, in a closed area of nothing, without a postage stamp and without a flag to establish jurisdiction, I've got nothing going in and nothing's coming out. How much money you got? Well, it's $275 an hour to talk. And you have freedom of speech at $275 an hour, and as soon as your money runs out, we will make a decision. We are practicing banking and commerce, and no matter what you think is happening, it never happened. Then you get to file an appeal if you don't like what nothing happened. How do you spell appeal? APP, which means no contract. And what does the word appeal means? It means the higher court will forgive the lower court for doing nothing about nothing with nobody and agree with it, unless it is something that will affect public opinion about how the court system operates, some genocide or apartheid case. Then they'll go ahead and they'll make a little bit of noise about it. And everybody knows O.J. Simpson, right? That was a $40 million trial, and it ran for like 9 months. That was a big joke for the simple reason that they had to go ahead and take somebody and do an elaborate advertisement to the world about how our justice system works. That's all that was, just advertisement. And since then we have, 20 or 30 different crime shows on TV that advertise and tell you what's going on. But that's not the real world. It really doesn't happen. Maybe one case out of 1,000 they might take and run a CSI on, but 99% of the time they just fluff it off. They don't have time or money to go ahead and chase it. So it all comes down to who you are, what you know, and what you put on your documents that come into court. I can write on a document, one of my syntax documents, file it into court and put one line in there, I want hot coffee on my table. The courtroom door says no food or beverages. And yet, when I sit down at my table, I will have a pot of hot coffee because I like to drink coffee. And I have a contract that I paid filing fees for to have hot coffee on my table, and that contract says that I'm going to have hot coffee, just to prove a point that that contract has jurisdiction in the court. Try it. I guarantee you'll get it. You say, Your Honor, so what? Court's out of order. I don't have my hot coffee. I put it in my contract. Bailiff, go get this man his hot coffee. It's part of his contract. Do it. You'll have fun. These planes breaks it up and creates the illusion. You can dissolve the planes and dissolve all the boxes by writing it in your document. Your lawsuit says there are no planes in this court. We are on a level playing field. We're going to use syntax language. There is no adverb-verb illusions. And what we say is not 2 + 2 = 4. And you do a disclaimer of that. Or you do, not a disclaimer, you do a claimer. Or closure is the word, closure. All maritime law, under maritime law, all contracts must have closure. Well, when you're in a syntax level of mathematics, believe me, you have a closure. Our documents, because we've had through trial and error, and we're up to 2,200 federal lawsuits in the last 15 years, we are at a level where we take into consideration all these different points of closure that are necessary. When the Supreme Court of Hawaii wanted to sell 1.2 million acres of Hawaiian homelands without lodial title, I was responsible to stop it. So I took the 50-page document that the United States Federal District Court in Honolulu, Hawaii, through the Supreme Court, and the Supreme Court judges all went to Washington, D.C. to go up against John Roberts and the 8 Supreme Court judges and argue why they had the right to sell 1.2 million acres of Hawaiian homelands. And I went ahead and I took the 50 pages and I syntaxed them and there wasn't one legal sentence in the entire 50 pages. It was just written in adverb verb. And it only took 6 sentences to articulate the fictitious conveyance of language and the damage that was caused because they don't have lodial, L-O-D-I-A-L. Location, D-I is original, A-L is contract. No location, original contract to sell Hawaiian land. And the post office doesn't have jurisdiction because they never had the correct sentence structure communication syntax on any treaty, trust, or contract with the Hawaiian people since Cook landed there in 1789. That totally wiped out all claims that the United States government has against the Hawaiian people. And so with that information, the United States Supreme Court reprimanded the Supreme Court of Hawaii that you people are illiterate, you can't read and write, and you tried to perpetrate a fraud against us, go home. You don't have lodial title, you can't sell the land. With 6 sentences in a 2-day head start, and I defeated them in 1 page. And if I can do it to the Supreme Court, and they have standing to take a Supreme Court of another court and knock them down, then the language that sets precedents, that syntax has jurisdiction over all fiction. And it does. So you guys have the power and the ability to go out there and use this technology successfully. On the back of my business card is the whole procedure how to prosecute judges and attorneys. It's already written there for you.